Hello everyone and welcome to today's Mondac webinar in association with Nico, Howe and Co, who will be discussing how to protect your trademark within OAPI and the best practices for 2023. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Vanessa Howe is a partner at the Nico, Howe and Co law firm, heading the intellectual property department. Vanessa has extensive experience managing IP portfolios as she advises and represents clients in strategic areas such as brand development and implementation, protection, maintenance, acquisition, litigation, and transactions. John Howe is a managing partner heading the corporate department. His expertise includes administrative and regulatory compliance, business law, corporate and commercial practice, corporate finance, global mobility and corporate immigration, intellectual property and innovation, labour and employment, investment, litigation and alternative dispute resolution, and tax. John advises clients on a wide range of corporate commercial matters and transactions in Africa, especially member countries of the organisation for the harmonisation of business law. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during the Q&A session, but please do reach out after the webinar. It's now my pleasure to hand you over to Vanessa and John to begin. Thank you.
Thank you, Dan. Thank you for the wonderful and very brilliant presentation of myself and Barrister John and our law firm. And as previously indicated, we will be tackling.
My apologies, Vanessa. Your audio is a little bit low at the minute.
Okay, am I clear now? Am I good now?
It's still a little bit quiet on my end.
Okay. Are we okay now?
That's a little bit louder. I think that will be okay for now. Thank you, Vanessa.
All right. Thank you so much, Dan. Thank you. So as we were talking about today, we'll be handling how to protect your trademark in the OAPI jurisdiction, and we will be tackling best practices for 2023 and beyond to enable you maximize and obtain the most out of your IP rights, especially trademarks. So we are going to comment our presentation, and we'll have our first slide coming up. So I think that, and I'm pretty sure that most of us already have an idea of what OAPI is, but just for housekeeping purposes, we'll just know briefly about OAPI. It's in English is the African Intellectual Property Organization. In French, Organisation Africaine de la Propriété Intellectuelle, and it's more commonly known by its French acronym OAPI. And this organization is a regional one. It created the primary purpose for the protection of intellectual property rights in all its member states. To date, OAPI has 17 member states. They are Benin, Burkina Faso, Cameroon, the Central African Republic. We have Chad, Comoros, the Congo, which is Republic of Congo, at Brazzaville, Cote d'Ivoire, Equatorial Guinea, Gabon, Guinea, Guinea-Bissau, Mali, Mauritania, Niger, Senegal, and Togo. And it's very important to note that this organization groups some of Central African strong economies, such as Cameroon, Ivory Coast, Senegal, and others. So the reason why the reason why this jurisdiction is prime market for most IP right holders. So we'll move to the next. And we'll be asking ourselves, why do you want to use the OAPI system? Why should you, as a trademark holder, consider registering your trademark in OAPI? And one of the most important characteristics of OAPI is that registering your trademark or any other IP right in this jurisdiction grants you automatic protection in all member states. We know that there are other regional groupings in Africa. For example, we have ARIPO, which is the African Regional IP Organization comprised of other African states. But one thing that sets these two jurisdictions apart or that distinguishes them is the fact that when you file for a trademark or any other IP right registration, it automatically covers all 17 member states. It provides a unified platform for the protection of IP rights. It's possible to designate a particular country. For example, you cannot say I want my trademark only in Cameroon or only in Burkina Faso. Rather, when you file your trademark at OAPI, it covers all of the 17 countries, which in itself is an advantage because you have one filing for all 17 countries. One filing equals to a reduced cost because in certain regional organizations where you have to designate countries you're protecting, it's very obvious that you will be paying designation fees or fees that are applicable to each of the member states. But since OAPI is considered as a single jurisdiction, we have a reduced cost where you have just one fee which is paid, irrespective of the countries in which you exploit or you use your trademark or commercialize your trademark. And because you have a single filing that covers protection in all of these countries, one thing that this does, or a very strong advantage to all the IP right holders, is the fact that you have a great ease in managing your trademark portfolios and managing deadlines. We all know how tricky it is to have to manage renewal deadlines for 17 countries, just covering OAPI if we had to have designation possible, or if we had to do national filings. Because we have a unified system where one application covers all 17 countries, therefore one renewal covers all 17 countries. So it's easier to keep track of your renewal deadlines. And we'll be moving to the next slide. And that will be handled by Barrister John on the availability searches.
Hello, everybody. Thank you all for your attention. Vanessa, thank you so far for edifying the public on these very salient points concerning IP protection in the OAPI jurisdiction in Africa. Taking up from where you've left off, and in the same vein, we're talking about the importance of certain prerequisites prior to thinking about registering or protecting a trademark or a brand within the OAPI jurisdiction. Here we're talking about availability searches. We always advise, potential investors or clients who wish to protect a brand or a mark to carry out searches to ensure that that particular brand or mark or logo has not been registered a priori. It is very important so that you avoid, contentious matters in the foreseeable future. You avoid opposition hearings or you avoid claim of ownership hearings. In essence, before you proceed to register the mark, you are sure and you are assured that this mark, that there is no risk, of confusion of this mark having been priorly registered. The importance of the availability search is equally convincing because when you conduct the search, the procedure has been simplified nowadays. Previously, it used to take quite some time, but now with the digitalization of information and data within the structure, such availability searches, the results are released or they are delivered within record time. So the investor or the client has enough time to make an informed and a determined decision as to how they wish to go about protecting their brand. When we ask about what type of search, the searches cover domain names, they cover trade names, company registrars, the web, most often we have clients who, on top of wanting to, search the particular mark they wish to register, also, wish to inquire whether, as a corporate entity, that company can equally exist. It usually goes hand in hand. So if we have an investor who wishes to invest within this jurisdiction and they wish to create a company or a legal entity within which to carry out their activities, we equally advise to carry out a search in that regard, so that if you're going to ascertain that, okay, you are able to proceed with this mark, then you can also ascertain that you are able to proceed with this particular legal entity to increase the protection that you will afford to the particular brand or to the logo. I think with regard to availability searches, I think that is it. Vanessa, maybe you could kick off, you could take on from there, or maybe if there are any other salient issues you wish for us to draw the public's attention to, you can make mention of.
All right, thank you, John, for that. Talking to us about availability searches, I think one important aspect to note is that availability searches are not only done to ascertain whether your mark, your proposed trademark is available, also whether a third party has filed your own mark as well. One of the very important aspects of litigation is that you have to ascertain whether the mark that you're looking to oppose has been registered or not, because the registration of a trademark is very pivotal in determining the kind of action that you're bringing. For example, if you have a trademark, let's say your trademark is called banana, and you realize that there's someone on the market exploiting that same trademark, what will direct you on your action is also know if that trademark has been registered. Because if the trademark has been registered, for example, you know that you have to be looking at, are you within opposition period, or if the opposition period has passed, are you still in position to bring litigation before the national court of any of the member states, or the member state in which the the infringer is registered. And also that will also enable you in the event where you are trying to look at infringement seizures or actions, because if the trademark has been registered, that will also direct you on whether you are doing a direct infringement seizure just against the goods that are counterfeit, or whether you are also looking to oppose that trademark registration for the court. So availability search is also used like an offensive mechanism, not only defensive in the sense that you're looking to see if what you want to file is available, but you're looking to see whether a mark that you want to oppose or a infringing, or a mark that infringes, or an exploitation by a third person infringes your trademark. You have to be sure whether their mark is registered or not, and then you'll be able to decide on your litigation options. So we'll move to the next slide. That has to deal with when to file a trademark OAPI. And from experience, most times we have IP right owners who file their trademarks in the region at different times. There are some who file it have already been exploited in the region at the jurisdictional already, and the reason that some of these IP right holders advance is that they want to see if the mark is going to be successful, if the brand is going to be successful before investing in the trademark registration. And for this, we consider that if you're already investing that much in commercializing a brand in the region, then therefore it means that that brand is important. And one of the ways at protecting what is important, protect that IP right, is to register it. So do you register it while you're using it? Do you register it before you commence your business? Do you register it, and is it possible for you to register and then stay for a while without exploiting? So from experience, what we advise IP right holders is to register their trademarks or whether it's a trademark or a commercial name before commencing their business. This is because, as already indicated by John, the availability search would have been done. That would indicate whether or not your trademark is available for registration. Now, if your trademark is available for registration, that is when you know that getting into the jurisdiction or the territory without IP right, registration, or exploitation, you are not going to face any litigation. So, before you commence business, we recommend that you do your trademark search and then you ascertain if that mark is available. But it's a lot costly if you have to commence exploiting a trademark only to be faced with litigation. That will lead to the cancellation of that trademark. So before you start doing your business, you need to be sure that the brand that you are exploiting is available. And once you're sure it's available, then you register it prior to commencing your business. And this is very important because when you commence your business fervently on the territory, you also exposing your brand to counterfeit and infringers. And therefore, if you don't have the prior right, because OAPI is the first to file jurisdiction, then you are on a weaker foot. You're putting yourself at a disadvantage. So in OAPI, it's very possible to register your trademark and not use it immediately. OAPI doesn't have a requirement of use when filing. It's very important to know that when you file your trademark, you have 5 years within which you must exploit that trademark before it becomes vulnerable to non-use. And it's very important that non-use cancellation actions are brought forward and can be applied to the entire trademark in all its classes or all its goods and services. So it's very important that when you register your trademark, you make effective use of that trademark under jurisdiction. Now, we sometimes have inquiries about defensive filing. In some jurisdictions, defensive filing is stated clearly, expressly in the regulations, but in OAPI, we do not have regulations or provisions in our banking agreement on defensive filing. Therefore, means that it's a gray area that most IP right and trademark holders can use to their advantage. In what sense? Defensive filings, you can, in a certain way, to register similar pronunciations or similar, um, mostly similar pronunciations of your trademark. Because bear in mind that when you're looking at the use or the commercialization of the trademark, what is normally referred to is the verbal element of the trademark. So there are some people or some good drinkers who will just literally have a different spelling, but when you pronounce it, it has the same. Take for example, we have Huawei, which is spelled Huawei, but you might have an infringer that would decide to register Huawei as in Wawei. It's spelled different, but when you're pronouncing it, it has the same pronunciation. Such that if I see the type and I'm like, oh, what phone is that? Oh, you say it's a Huawei phone. And people automatically presume that there's a relationship between the two marks, whereas there is no relationship. So that's where defensive filing comes, where as a strategy of better protecting your mark, you can decide to register similar pronunciations or similar representations of your mark. Then again, we have the aspect of use of the mark, where it is susceptible to non-use cancellation actions as well. But defensive filing is an option in the jurisdiction that all IP right holders have to consider for better and strong protection of their IP right. Now, one of the things that is very rife in the jurisdiction is, distribution agreement between brand holder and local. It's not always possible for all IP right holders to set up shop in the member state of OAPI. So what is done is sometimes there are exclusive distributor agreements that are entered into. And now you enter into a distributor agreement. You know how sometimes contracts and some this kind of agreement work. Sometimes you have breakdown in relationships. When one party doesn't fulfill their own end of the bargain, and then you have some distributors who go ahead, and this is something that is live now. Go ahead and register that trademark in their name. And now when relationships break down, the real right holder is in a is difficult because distributor had a prior registration of his own trademark, and it's worse if position period has elapsed and now you have to go through the courts. We understand how lengthy the procedure is, everything. So it's very important that if you're contemplating getting into, a distributorship agreement or any other form of agreement with a third party or representative agreement with any third party on or a member state, it's always important to have your trademark registered. This is to give you the upper hand in the event that your partner or the person in which you have the agreement decides to go and surreptitiously register or file your trademark. So we're moving to the next slide. We'll be looking at enforcement. Now you've done your validity search and you have registered your trademark, and now you're looking at enforcement. We've just spoken about counterfeit, infringement, and we talked about litigation. Now, we all know that litigation has its sister, which is it's an alternative to this, but we have negotiations, mediations, and everything. We all know that OAPI has a mediation and arbitration center. It's the center is not yet taking on cases at the moment, but that is, an avenue which IP right holders should bear in mind that is available for them in the future for the resolution of their disputes. Now, one of the things that we find very, very useful in enforcement are C&D letters. C&D letters really, that cease and desist, are just barely basically stating, IP right holders' claims and asking the other party to stop. What we've seen sometimes is that these C&D letters, if well done, are effective. And they also save time and the cost of the trademark holder. Because for every litigation, either opposition at OAPI or the courts, the trademark holder has to pay the lawyer to represent him or her before either OAPI or the civil courts. Which, if you did that before the civil court, it's going to be a long time, sometimes minimum of a year to get your case resolved. And that means that you have a lot of costs that will pile up. So we always advise that, once you determine that there is an identical or a similar trademark to yours that has been registered, we always recommend you to start with a C&D letter and give the other side a reasonable time frame, 14 days, 21 days, 30 days, within which to respond. Obviously ensuring that that leaves you well in your opposition window. And if they don't, then you can start to pursue, a full litigation action either before OAPI or before the national court. And one of the ways for you to have the upper hand is to have a very strong monitoring system. We have several copyright owners who register their trademark do not bother monitoring for identical or similar trademarks. And currently at OAPI, starting from 2022, when Annex 3 of the 2015 macro agreement came to force, position now done within 3 months of publication of the application for registration. Previously, prior to 2022, January 1st, it used to be 6 months, and it's 6 months from publication of the registration, which therefore means that in order for any IP right owner to really protect itself, it has to have a strong monitoring system enforced to monitor all the applications, ensure that any similar or identical trademark is caught and is brought forth for consideration on the chances of success of an opposition action. So for effective enforcement, one very good practice to have is to have a strong monitoring network. You monitor your trademark. It could be in the trademark journal. We have Madrid, the OAPI portal, and also online as well. Sometimes you call the web for use, and also even in the OAPI member states, sometimes depending on the value that you place on your brand, if you're a very big trademark right holder, you can also have independent investigations done on ground to really know the volume of the counterfeit goods, to ascertain in what towns they are being brought, because the terrain here in Africa in terms of marketing and infringement is quite different, because you have to go into towns, into different areas to be able to ascertain the volume of goods. You need to ascertain the head honcho of the whole ring, the whole counterfeit ring. So it's very important to have a monitoring system. And for some brand holders, passive litigation is the key. The stronger or the more litigation you have, the more but the stronger your brand grows, in the sense that you tend to have fewer or less identical or similar trademarks to yours in the market. So it gives your brand a lot more visibility and a lot more clout in that region. So one aspect that brand holders need to consider is bringing litigation of any and all identical similar marks to ensure that it remains at the top, and it protects its rights. So we're moving to the next slide.
Excuse me, Vanessa.
Yeah.
Yes, I just wanted to throw some light on the issue of enforcement. If we can go back just a slide, please. Yes, on the issue of enforcement, I think it is important that our audience knows that enforcement is twofold, and usually, for effective and more efficient results, it might mean, in engaging on both fronts. So you're trying to enforce your rights, through the OAPI, African Intellectual Property Organization, or you use the local, local measures, local remedies, being the courts or the forces of law and order. If we're talking about seizures, if we're talking about engaging actions in court, which sometimes might even be more expeditious. So in terms of enforcement, we don't kind of limit either arm. We say, okay, both options are on the ground, and you can either engage both concurrently or one after the other. And talking about the realities on the ground, there are a lot of bottlenecks. There are a lot of difficulties with regard to enforcing. For those who have had experience, working, or having operations in the African market, in the African jurisdiction, how sophisticated and delicate that can be. Identifying counterfeiters, or engaging procedures which have a desired outcome. Understanding also, that there are certain practices that are borderline, corrupt, which could adversely, influence, such proceedings. But that does not deter, the action, and we do not, we can only encourage, victims of such prejudice to engage accordingly, irrespective of the difficulties on the ground. When the work is properly done and the elements are in place, then most often than not, positive outcomes are achieved. So that was just an aside just to add, because we understand that a lot of parties kind of are reluctant to engage actions, locally, especially if they don't trust the system or they don't have some assurance as to the outcome of same. So those factors should not be a deterrent. It should rather be an impetus for actors in this sector to engage. So that was just to add, Vanessa.
Thank you, John. Thank you so much for your addition. Dan, so can we move on to the next slide? Okay, so we are at the point where we are looking at what to avoid and pitfalls that you can avoid to have a stronger brand protection in the OAPI jurisdiction. And the first thing that we would ask you or we recommend is that the IP right holder avoid delayed registration. Sometimes business owners or trademark holders focus a lot more on the business side than the IP protection side. And sometimes IP is like the back burner. It's like the last thing that comes to mind. It's almost like, okay, I've set up my business is thriving, let me consider my trademark registration. Whereas literally the IP right is supposed to be at the forefront. Because when you have big companies out here, and let me just give an example vaguely, we're looking at maybe Apple or Google or Samsung, so many big brands out there, we're looking at what gives them that that value. Is the IP assets. The IP assets could come through trademarks, it could come through patents, it could come through designs or utility models, but IP is a very, very strong part of every business culture. Literally, that is what the business is. Because the name of the business itself is already a distinguishing factor, which sets it apart from any other business. So when you have companies being bought or being sold for a certain value, one of the considerations that they have is that business's assets, and IP assets is one of them. And for many companies, it holds the largest share or larger percentage of the business assets. And therefore, when looking at what is best for that business, the IP assets have to be at the forefront. But we realize that in most cases and in most instances, the focus is placed on running the business, getting it set up, getting a local office or having a distributorship agreement or looking at import and export, getting exonerations, licenses, but nothing is being paid. No attention or little attention is being paid to what sets that business apart, and that is its IP assets. And frankly, a lot of it would be a lot better if IP right owners could pay a lot more attention on protecting their IP rights by not delaying registration till when maybe they are facing litigation, then they decide to register their IP right, or when they realize that the business deal gone sour and then they decide to register their IP right, or when they realize that they're facing stiff competition from another company that has come up, then they decide to register their IP right. Delay registration is a very big thing to be avoided by all IP right owners. We should strive as much as possible to ensure that as soon as you decide that this is my business name, this is the trademark I want to exploit my goods or services under, and you have done your search and you are sure that you're getting into that market, you proceed with your registration of a trademark. And we're looking at what to avoid: getting into business deals without trademark protection. It is always unfortunate, and sometimes we are faced with cases where we know that this trademark belongs to party A, but his hands are tied because his business partner registered his trademark 4 or 5 years ago when they just inked their agreement. and everything was going on well until it started going bad. And now they're faced with, you know, a situation where even though it's a trademark, you know, they are the first to file, and then they have to go through a lengthy process of litigation in court. And it's always nerve-wracking to have clients, you know, desperately trying to, you know, assert their rights over what is originally theirs. Yes, so Pastor John, I'm switching on to you to tackle the next 3 points.
Yes, please. Can I just add to what you've said concerning this particular issue? You know, of basically, we have several instances which we term, you know, we have clients who kind of put the cart before the horse. When we began this presentation, we stressed on the importance of carrying out an availability search before filing your trademark. It's the same thing, you know, in the same vein, before you invest in the country, before you ship your goods or your produce or your products, you know, into a particular market, you need to ascertain that, you know, those goods will not be counterfeited. And the best way to do that is to protect that brand. So even before you decide to set up the company, or you decide to set up distribution, you know, engagements, it's important for the particular aspect of that company to be protected before you even go into the market. So in essence, you avoid, you know, contentious issues tomorrow, which are very, very usual, you know, in this sector of activities. That was just to stress on the importance of carrying out this due diligence and ensuring, you know, protection before actually entering that particular market. So I think we can move to the next slides, as you were saying.
No, it's the same slide. Yeah.
No,
okay,
I think
we
you will need to go back. Yes. Okay.
So what we have, another thing that we have to avoid is delayed litigation or counterfeit action. Earlier on, we spoke about litigation, and we asked ourselves, you know, to litigate or to not. Do you go to court, or do you start with a cease and desist? Like, what action is best to take when you're faced with a counterfeit or infringement? And one of the things that we will really strongly advise is quick action. Quick action, especially when you're dealing with counterfeit. The terrain back here is such that once goods get onto the local market, it's very difficult to get a grasp of them, because in instances here you have what we call non-local markets. You can have sheds, or, you know, little shops, little boutiques, right? So let us say, for example, that let's use what is really rife in our market now. That's fake alcohol, that's counterfeit alcohol, whiskey, you know, champagne and everything. What you see in a shed or what you see in a boutique in the market here is not up to 1% of what is in their warehouse. And that's what I'm talking about. Once the goods get onto the market, it's a whole other ball game. Why? Because you have the main importer. The main importer has 10 sub people that he delivers his products to. And now what he does is that he will give party A, let's say 100, let's just say 500 bottles. He will give party B 700 bottles. He will give party C 400 bottles. They are never going to have all those bottles in their boutiques at the same time. Most times they will stock them up in the same nearby warehouses, such that when you now discover that if you go and you do a raid only on that boutique, after a few weeks, you're not going to see your products, for example, 2-3 weeks, when things are still, you know, hot. But when things cool down, give a month or two, they're back onto the market because things have cooled down, and they've just simply gone out to their warehouse and then, brought out other stock and made them available to consumers. So one thing when we're talking about monitoring and we're talking about on-the-ground monitoring is that you have to know, if possible, have private investigators where those goods are being, or where those counterfeit products are being made. If they're being imported, you have to be able to stop them at the ports before they get onto the territory. Because once they get onto the territory, they sent to dispatched to different regions, different towns, different markets, even in the same town, and it becomes very, very difficult to do, to have an effective counterfeit action. But now, once you discover that this is where these goods are placed, for example, as a result of your investigation, what we recommend you to do is to have a cohesive or a fast action at the same time, because these people are networked. If you go and you do a seizure on party A's warehouse, it's gonna tell party B and party C that my goods were seized, and they are all going to be on the lookout. But if you do that seizure at the same time, they don't have time to warn the other person because they are also undergoing the same thing. So it's very important to have effective monitoring and investigations in your markets of interest, because we understand that not 17 countries will be your market of interest. There are some brands whose market of interest in Cameroon is Cameroon. And there are some brands whose market of interest is Senegal and Ivory Coast. There are some brands whose market of interest is Togo and Congo. So those countries that are your market of interest, you have to ensure that you have a firm grip over, your monitoring network. That's something that you have to do for the effective enforcement, because if you do not monitor what's on the ground, you're not going to know, or you're not going to have a very clear picture of the amount of infringement that your trademark is undergoing. So we recommend that once counterfeit is discovered, once any infringement is discovered, this has to be treated timelessly, and quick decisions have to be made on whether or not to proceed with the litigation. And we do understand that for some IP right owners, there's a lot of consideration given to the volume. The volume of the goods have to be compared with the value, the cost of litigation. So if the volume is not so much, and many brand owners have a threshold what they consider minor infringement and what they consider large scale infringement, this is not the same scale or the same rate with all brand owners. But once you discover counterfeit or infringement, we encourage you to take swift action, to have your meetings quickly to ascertain the damage done and decide if or not you want to handle litigation. Because if you decide to do litigation, the longer you wait, the less chances you have of effectively, getting the whole or the entire network. And another aspect that we're looking at is failure to renew. And again, this takes us back to the advantage of the OAPI jurisdiction, where because you have one registration covering 17 countries, you don't have to remember 17 different deadlines to cover all the countries. You have just one deadline that you have to remember. Now, it's very important that when you're monitoring for infringement by other parties in different countries, you are also monitoring your deadline and ensuring that you renew it in record time. Because when your mark is not renewed, it falls into the public domain. And when it falls into the public domain, it means that at that point in time, it's free game for third parties. And even though there's a provision in the Bangui agreement that says that, your mark that has, lapsed due to failure to renew cannot be registered by third parties within 3 years of, of its lapse. You have to bear in mind that your mark is still open to infringement. I'm just putting infringement lightly because the mark isn't even, extant. So therefore, it's not an infringement per se. But because your mark is open, it could be exploited by any and everyone. And even if you decide to actually come back and, maybe restore your trademark or refile it, your options are very limited against the people who are exploiting that trademark while it lapsed. So it's not wise for any brand owner to believe that, oh, because I've owned this brand for 20 years and the trademark lapsed for 1 year and I did a restoration or I refiled it, it means that I can come after someone who was using it during that lapse period. It's going to be extremely tricky. So if there are any brands that the IP right owner deems important to them, then they have to ensure that the marks are renewed. So, John, you have any other additions?
I think principally on the aspect of failing to renew, you are right in saying that if your mark or the right lapses and somebody else takes over, it's not an infringement per se. But I think this is all part of the importance of monitoring. When we talk about monitoring, it's not just to protect, it's not just to prevent infringement, but it's also to ensure to ensure the continuous protection of the brand. So it's very important to take note and to take cognizance of deadlines. Deadlines are very, very important when it comes to the protection of IP rights. Reason being that these are the same deadlines that really prescribe the parameters of protection. And if deadlines are not respected, then you find yourself in a position where you have to remedy a situation which could be more costly and potentially prejudicial to your operations or to your mark itself. So it's very, very important. Sometimes, you have persons who claim, okay, who think that because they are not actively exploiting a mark, they could allow it to, they could allow the time period, the validity to lapse. And then subsequently, another party starts exploiting the same mark, or not only exploits, but, comes up with something similar to that and starts exploiting. It becomes really, really difficult for you to come around later on in the future and try to reclaim a mark which is already being actively and economically exploited by another party. So these are some of the nitty-gritties which when we overlook, it tends to come back to affect us adversely in the foreseeable future.
All right, John, thank you. Thank you very much. I think that we are 10 minutes away, and Dan, we are hoping that you could lead us with the questions and an answer session.
Absolutely. Just before we begin, I would like to say a big thank you to Vanessa and John for your insights and your expertise today. We really appreciate it. It's a really fascinating discussion. We do have a bit of time for a Q&A. If you could please send your questions in, that would be fantastic, but we've already had a few questions in from our audience. This question is from Punyatoya. I would like to know about opposition procedure in OAPI.
Okay, thank you. So,
Vanessa, by the way, Vanessa is our expert, very seasoned litigator, both on the alternative dispute resolving side and also on the litigation side. So we're talking about oppositions, anything that has to do with, contentious hearings in OAPI. Vanessa is well informed and equipped to handle that. So Vanessa.
Thank you so much, John. So about the opposition procedure in OAPI, now what we have is we have a little bit of a mix of two systems, and I'm going to explain why. So before 2022, 1st of January, the opposition procedures were as such. When a mark is filed, it proceeds to grant and registration, publication, and then any interested party could bring an opposition within 6 months of publication of the registration. Now, this was a bit tricky because the issue was when you're putting a registration onto the mark is literally canceled, the right owner could still exploit it. So it was more of an avenue where people who were, willful, infringers could still continue exploiting till it possibly went up to appeal, which could take like 3 years, in some cases 4. So bring on January 1st, 2022, and the opposition window became 3 months. And this was 3 months from the publication of the application for registration. So when your mark is filed, the registry will issue an official filing receipt, and then at some point they will publish the application for opposition purposes. If your mark has no opposition, then the examination will proceed to registration and issuance of the certificate, and there will be a second publication of the registration. But now, if your application has an opposition, the examination is stalled until the opposition process is actually comes to an end. It could come to an end through when the hearing takes place, or it could come to a point where the parties reach an agreement and they notify the registry that we've come to an agreement. I'm going to, voluntarily renounce my mark. It could come to end by a number of ways. And or it could write the entire process up to appeal if applicable, and then depending on who wins will determine whether the application will proceed to grant or whether it will be canceled. So currently we have a mixture of the two, because we still have applications that were filed prior to January 1st, 2022. So any trademark that was filed prior to January 1st, 2022 is under the 6-month opposition window, because that is what was in place. That's the rule, or that's the law that was in place when the trademark was filed. So even if your registration is published today and you file your trademark in 2021 and it's published today in 2023, what is going to be applicable will be the rules and regulations that were enforced at the time of application. And that will be the 6-month opposition period from registration. Because that application filed in 2021, the application wasn't published for opposition purposes. And that's the reason why we are talking about ensuring that you monitor the trademark journals, because you're not only monitoring current applications that are being filed, but you're also monitoring trademarks that were possibly filed in 2020 that have matured to grant in 2023, for example. And that therefore means that you will be opposing a registration, and your opposition will be based on the Bangui Agreement of 1977. That's the previous version. But now, for every trademark that was filed from January 1st, 2022, that application will be published, and that is what you're going to oppose. You will be opposing the trademark application, and the deadline is 3 months from publication of that application. And the rules that will apply are the rules of opposition under the 2015 Bamako Agreement. And any argument or any provision that you use in your opposition has to pertain to the various Bangui agreements. For example, if I'm opposing a registration of a trademark that was filed in 2021, I will not be using the 2015 Bamako Agreement because that's not what was enforced at the time of filing. So that's why I said that at the moment we're having a mixture of the provisions that pertain to oppositions, because personally I've had to deal with oppositions of trademarks that were filed before 2022, and you have to use the Bangui agreement because the terminology and the precision of the language. Because, for example, it says you already have the deadlines that are a very big flag, because of the previous one, it tells you it's 6 months, and the new one is 3 months. So you cannot take the 3-month opposition deadline and apply it to a mark that was filed pre-2022. So that's the bit of the mix that we have. So what happens is, irrespective of what regime you're filing your opposition under, the process is similar. You have to file your opposition action at the registry. You have to set out the basis of your opposition, which must be tied to the Bangui agreement enforced at the time of filing the application, not at the time of registration, at the time of filing. Now you have to, submit your written evidence. It could be annexures on use. Even though use is not required, for opposition purposes, it helps if you tell the opposition commission that, look, I've been using my trademark. This is the volume of, of the products that I'm bringing in under my brand into your member state. You look at, you have to, compare and set out the identical or the similar nature of the marks. Now, if it's your brand that is being opposed, you're obviously going to have to be saying, look, these marks are not identical, they are not similar. So what happens is you file your opposition at the registry. It's the registry that is going to transmit that opposition to the other side. The other side has 3 months within which to respond, and this period is extendable once upon request. And your request to extend this 3 months deadline has to be done during your initial 3 month period. So if the 3 month opposition response window elapses, you cannot request for an extension. Your extension has to be done within that initial 3 month response window. When you make that request, the registry is going to now consider it and decide if to grant that response, and they will notify you, and the other side, when they've decided to grant the response, they will indicate the exact date on which you're supposed to respond. Now, when you file your response, the registry is going to transmit it to, to the other side, or when the other side files their response against your opposition, they're going to transmit it to you. Then you have the opportunity to do an additional submission if there are any claims that you wish to rebut or any additional information that has since come to light. You can submit that, and then the registry, the OAPI Commission, is going to set out a hearing date, which is usually based on the schedule of the sequence in which the oppositions come in, and then you're going to have a hearing where you're going to argue for why the adverse mark should be canceled, or if you are the defendant, you'll be arguing why your trademark should not be canceled. Once that is done, the commission is going to deliberate, and they're going to hand down a decision which is appealable. Under the 2015 Bamako agreement, your appeal deadline is 60 days. Now, under the old provision, which is pre-2022, your appeal deadline is 3 months. So there is that, again, depending on under what regime you're bringing up your opposition, or under which the opposition is filed, the appeal deadlines also differ. So, and that's it. If there's an appeal that is filed, the process goes on again until the appeal decision, which is the final decision and it's not appealable anymore, is issued. If no appeal is filed within deadline, the opposition commission's decision stands. And it's very important to note that a decision itself does not necessarily stop infringement. We've had instances where a decision was issued whereby the mark was canceled, but the other side continued exploiting the mark on the market because the consumers do not know that the mark has been canceled. They just keep buying because they've been seeing it in the market. So when you get a decision of cancellation of another brand, it's always recommended to go on ground and literally ensure that you monitor to ensure that that mark is not being used. Because if that mark continues to be used, then you now can bring infringement seizures because the mark has been canceled already. So yeah.
Excellent. Brilliant. Thank you very much for that, Vanessa. A very comprehensive answer. So I hope that answered your question. But as I say, to anybody watching today, please do get in touch with John, with Vanessa, if you require any additional information. Looking at the time, I'm afraid we are going to have to wrap up there. But once again, I would like to thank John. I would like to thank Vanessa for your time, for your expertise and insights today. We really appreciate it. We hope that we can see you again soon. And to our audience, thank you very much for being with us. We really appreciate your time. So John, Vanessa, I'll let you say goodbye for today.
Thank you, Dan. Thank you, everyone who turned up today for the webinar. We appreciate you, and we hope that it was an insightful one. Yeah, do reach out to us with any questions that you have for any further clarifications, and we look forward to speaking again with you soon. Thank you, Dan.
Thank you. Thank you, John. Thank you, Vanessa. We'll speak soon. Goodbye.
The same time. Thank you, Dan. Thank you, everyone. And hopefully we can do this again soon. Thank you very much.
Absolutely.